Hello, my name is Jay Chauhan. I am a member of the Angel Mentorship Group. I head that group, and this short video on wills and the ancillary matters relating to the wills is to try to explain what other things you have to think about when you, as a lawyer, are preparing a will for the client. So I won't go into details of the typical things that are taught in the school, as well as typically learned in the practice. But for these people who are new in the profession or the client is not familiar, this video is designed to address those people who would like to think about issues other than the technical law. But issues that are relevant in preparing a will includes making sure that when you sign the will, it is signed by the person who is called the testator at the time of signing with two witnesses. The two witnesses should be seeing the executor sign at the same time, and then it becomes a technically valid will. In the law in Ontario, the holograph will signed directly by the person in his own handwriting is still binding and acceptable, but I strongly recommend that if you're a client or a lawyer, that you recommend to the client that it is important to prepare the will properly, because there are many issues other than simply the legal effect of that will to make the will effective and to carry out the wishes of the testator, including, for example, who will be your executor, how will you appoint the guardian, what will you do for the obligations of the trustee under the Trustee Act, etc. So many issues, and how will the next generation and the generation after will benefit if somebody should die as a spouse, and what happens if there's an accident, the two people die together, what is the effect? All these issues are not addressed typically in the will. The other question is the storage. Where would you store the will? And here is an envelope, for example, of the will as to how you keep the will in a storage area with the information and instructions you give to the client to tell the person to make sure that the executor knows where the will is. Now, one of the questions that you would think about is that other than the executors, should the beneficiaries know about the content of the will? So the lawyer's role is to simply advise the client, who is the testator, person signing the will. But in my view, it is good for them to get the consensus in the family as to how they will be telling the family members as to the will. Because it's a family event. Actually, when a person dies, it's the beneficiaries who have to survive the event and distribute the assets. Some other questions which are ancillary to the preparation of the will is, what is the tax? The Ontario has removed any tax on inheritance that used to be there once a long time ago, a few decades ago. The only tax now applicable is the capital gains tax, which does not apply to the residential property. It applies to the capital property. And in the year of the death, the executor should file a return in that year, and that tax return should be completed after the person dies by the executor. So that's called the terminal. The tax return is required to be completed. So these are some of the questions that I inserted to the preparing of the will, and I hope that was helpful. I'm doing a seminar next week on the 15th of November 2018 on real estate. Hope you join, and to come to the seminar, and this is a CPD seminar, please write to me or to Elham in our office at elham, ELHAM, at jjohn.com. Hope you enjoyed the video, and keep in touch. Write your comments below. This is Jay John on this video.